Senator Stone is here. Could you take on file item 13 and chair that? I'm not sure if I have enough time to go over it. Energy's about ready to adjourn, and I have to add on. So, but I'm up next. I'm here, Hill. Okay.
Hey, Madam Chair.
Yeah.
Okay. Good morning, Senator Lar. SB 1227.
Thank you, members. Senate Bill 1227 would require the California Conservation Corps to collaborate with the California Department of Veteran Affairs, in addition to Employment Development Department, to better assist our Veteran Corps members transition to employment after completing the Corps program. The Corps employs young adults between the ages of 18 and 25 and up to 29 years of age for veterans for a year. The Corps participants assist with emergency response situations such as fighting fires, floods, and pest infestations. Between the years of 2013 and 2015, 292 veterans participated within the program, of which 174 found employment after completion. According to the report by the California Research Bureau, young veterans between the ages of 18 and 34 have a higher unemployment than their civilian peers. Although transition services for Corps members are in place, the current statute is silent regarding Corps members who are veterans. Unique characteristics attributed to veterans, a veteran's experience may not fully be addressed through EDD and the Corps employment efforts. This presents a gap in transitional services for veterans participating in the Corps. To that end, CalVet's experience in helping veterans uniquely positions them to best sustain the employment efforts of EDD and the Conservation Corps. By ensuring a smooth transition from Corps membership into jobs, we are making good on our promise as a state to stand up for our veterans. This bill ensures that our veterans have tools, all the tools they need to succeed. I respectfully ask for an aye vote.
Thank you, Senator Lar, for your testimony. You have some witnesses here today.
Yes.
Hi, Lorraine Ploss, this on.
Welcome.
Louder.
Just bring it a little closer, yeah.
Hi, Lorraine Ploss, American Veterans and Vet Supports this.
Thank you for being here.
Pete Conity, representing the other veteran groups listed on your analysis. An interesting factoid is that the California Conservation Corps was founded and run by two Vietnam veterans, B.T. Collins and Colonel Jack Dugan, and it started under Governor Brown in his first term. They have always done a very good job helping veterans, and I think this is, we need to bring CalVet into the mix so that we can help more veterans. Thank you.
Thank you for your testimony. Okay. Do we have anyone who would like to speak in favor of the bill?
Good afternoon, Chair and members. Katrina Robinson on behalf of the California Association of Local Conservation Corps and the Long Beach Conservation Corps in support. Thank you.
Thank you for your testimony. Any others in support? Any opposition to SB 1227? If not, take it back to our fellow senators. Anybody? Questions or comments?
No, I'd be glad to move the bill.
Senator Lar, would you like to close?
Thank you, members. I appreciate your support. And just to note that actually today is Vietnam Veterans Day. So thank you to all the amazing veterans for their service again to our great country and our state. So I respectfully ask for an aye vote.
Thank you for bringing it forward. We'll go ahead and call the vote. And this is going to pass to Veterans Affairs.
Senators Pavley.
Aye.
Pavley, aye. Stone.
Aye.
Stone, aye. Allen. Allen, aye. Hertzberg. Hueso. Jackson. Monning. Monning, aye. Vidak. Vidak, aye. Wolk. So it has 5 votes, but we'll put it on call so members can.
5 votes, Senator. We'll put it on call and tally it up.
Thank you, Mr. Chair, members.
Thank you for
All right,
testimony.
thank you. We still have Senator Hill has one more bill, and I have 2 more. If no one objects, I'll fill in till Mr. Hill gets here. There's no reason to lift the calls yet, is there? There's a lot of people missing. Okay. Senator Stone?
Oh, she's going to do hers? We're at 1262? 1262?
Senator Stone, I'm trusting you with my fate, which is darn scary.
I'm very honored, Senator Pavley. Thank you very much, and welcome, and you're here to testify and present SB 1262.
That would be it.
Yes, ma'am.
First of all, let me start out by saying this bill is going to take a lot of additional work. We get that. It's come out of several different approaches. One of it was relating to the passage of the Sustainable Groundwater Management Act that I authored along with Assemblymember Dickinson back in 2014. We have a lot of interconnecting laws when it comes to ensuring that our water supply availability is given proper consideration in relation to land use plannings and vice versa. Whether it's agriculture or building new homes, you want to make sure there's enough water, not just surface water, but groundwater. We've had some past bills back in 2002. I actually remember them both. One by Senator Jim Costa, down from your area, Mr. Vidak, and one by Assemblymember Sheila Kuehl. We called those the Show Me the Water bills, and it related mostly to subdivisions of 500 units or more, that you had to be able to show that there was enough water to provide water to those homes, the people that are going to be living there in the future. So what this bill does is sort of takes the Groundwater Management Act, and not just surface water, but groundwater, and says we need to show me the water when it relates to making sure there's adequate water supply. So this is sort of a two-bill package. There's this bill, the Pavley-Wieckowski bill, but there's also coming soon, 1263, a Wieckowski-Pavley bill, really relating to specifically safe, affordable drinking water initiative. This has really brought forward, some of the elements of this bill is brought forward by the administration, and they're trying to roll out a safe drinking water program. How can we ensure that people in communities, particularly in small rural communities that don't have access to municipal water districts, they will have access to safe drinking water, especially in basins that are severely and critically overdrafted. It's a real issue, and looking at Mr. Monning, you're starting to see that. Mr. Vidak from East Waterville to, we know in Watsonville, you're getting notices. Your water's unfit to drink, don't use it for cooking either. That's a problem, but do we keep adding to the problem? So this bill is a takeoff on the Show Me the Water bills relating to groundwater. So what does this bill do? It integrates groundwater sustainability agencies and consideration of groundwater sustainability into land use planning. It prohibits the use of groundwater to supply new development if the groundwater basin has been deemed out of compliance with SGMA. It prohibits the use of hauled water to comply with Show Me the Water bills. For example, a developer can't say, well, we know the groundwater is contaminated, we can't use that, and there's not enough surface water, so we'll just haul it in from somewhere else. That's actually happening as we're providing water supply to too many homes in California. It creates a process to discourage, or we can rephrase that, to encourage creation, not to encourage creation of new water systems, but when geographically and economically feasible, connecting it to existing systems. That's not being done now. We should be doing more of that so people have access to safe drinking water. The analysis points out that the LAFCO provisions in the bill need work. I agree with that. Water agencies and LAFCO, these need to be resolved. The analysis also suggests an amendment to the planning and zoning law, and I'm happy to take that amendment. We'll do that in governance and finance. That's the amendment verbiage is on page 9 in your analysis. You can review that. And we will need to review also, it's not part of this bill now, some people on all different sides are looking at what is magic about the 500 unit threshold. Should that be modified? Should it be modified in another bill? We're just trying to make this, our bill, consistent with the Sustainable Groundwater Management Act and show me the water. So work to be done. I actually look forward to having a discussion with some of the opposition to the bill. The goal is to update the various water and land use planning laws to more fully reflect and become compatible with SGMA. So with that, glad to have witnesses testify.
Thank you, Senator.
Good morning. I'm Jonas Minton with the Planning and Conservation League. Back in 2001, when the Show Me the Water legislation was originally enacted, I served as Deputy Director at the California Department of Water Resources. I can say that, frankly, we overlooked the critical importance of groundwater supplies. SB 1262 will correct that oversight. Let me comment on just two provisions of the bill. First, it prudently excludes groundwater from probationary basins as a water source for planning purposes. It just doesn't make sense when we are in an area that already has problems to make that problem worse. Secondly, as this bill moves forward, there'll be an opportunity to revisit the definition of a project as 500 units or more. We now know in California that more than half of our development is below that threshold. Criteria parallel to other legal requirements, some 15 units in other sections of California law, should be looked at. We support moving this bill forward today. Thank you.
Thank you for your testimony.
Yeah.
Hi, my name is Debbie. I'm with Community Water Center in support of this bill. For many of the reasons that my colleague Jonas has mentioned, the drought has shown the impacts of improper use of water. We support the common sense changes to the water supply assessment that this bill makes. As mentioned, additional analysis on groundwater as the primary source and the prohibitions on use of groundwater in a probationary basin or hauled water protect not only the groundwater basins, but the health and safety of people who will be relying on these water sources. Furthermore, having land use agencies look at the status of their groundwater basin and provides a tie to the goals of the Sustainable Groundwater Management Act passed 2 years ago. Community Water Center stands on the side of promoting that the bill should amend the 500 current standard down to 15 because that's consistent with the statutory definition of a public water system. And that ties in really well with the sister bill of 1263, which will allow the State Water Board ability to permit a new public water system, which again is 15 connections or more. So we look forward to working with the author's office and other stakeholders on this bill.
Thank you for your testimony. Is there anyone here who would like to speak in support of the bill?
Kyle Jones of Sierra Club, California, also in support. Would like to echo the comments to look at that number, dropping it from 500 to 15. Thank you.
Good morning. On behalf of Clean Water Action and the Leadership Council for Justice and Accountability, we support this bill.
Good afternoon. Steve Cruz on behalf of the California Building Industry Association. CBIA has an opposed unless amended position on 1262. We are not opposed to the underlying objective of integrating groundwater management planning into the Show Me the Water laws. Our concern is where and when that information is included in the process, and I'll outline those in a moment. We have met with the author's office on a couple occasions now, so appreciate Dennis O'Connor meeting with us and going over our specific concerns, and we're hopeful that we can address these. I think conceptually there was some agreement on that, but how we could accomplish it is important to us. And so just very quickly to sort of review some of our concerns. 1262 requires a new technical report, and they apply that as part of, on a project-by-project basis, as part of new development as is considered. Our belief is that it should happen more at a programmatic level. So you're looking more long-term and earlier in the process, so there's more certainty for property owners and developers. And we've suggested doing that as part of the urban water management plan. Those are updated every 5 years. Our concern with doing a project-by-project approach is that it acts as a litigation magnet for opponents to new housing, as is often the case. And you know, it's used as a reason for opposing a project. And it's, again, it's a water supply assessment is done. It takes significant time and resources to complete that process, and we don't want to add to that and add to the CEQA process. The second issue on the probationary basins, the bill as drafted proposes to cut off new housing's ability to use groundwater in a basin designated as probationary by the Water Board. And our concern there is that we do not have the authority or responsibility to develop these plans, and so singling out new development for failure of another party to abide by those laws would be inappropriate. And so it punishes us, and it should be it's not appropriate. So we would suggest that they look at another way of sort of incentivizing and encouraging those water districts to comply. Finally, we join others in expressed concern. It's also the senator pointed out that should be willing to fix on the CEQA issue and the timing, and that's identified on page 10 of the bill, subdivision D. It does not work because of the timing. Just to reiterate, so LAFCO, our responsible agency under CEQA, and only act on a project after the city or county has completed the CEQA process and the project is approved. The bill was written would require LAFCO to act before beginning the CEQA process. So it's sort of backwards, and that needs to be fixed. So those are our concerns. Again, I think, you know, we want to work with the author to try to fix these issues, but our issues are serious, and we're hopeful that we can resolve those as it moves forward. And Nick Camerata from CBI is here as well to address a separate issue.
Hi, Nick Camerata on behalf of CBIA. Sorry. Can you hear me now? Okay, thank you. I just wanted to address the issue of why we're at 500 units and why our current position, oppose unless amended, and a willingness to work with the author's office in trying to achieve the goals of tying sustainable groundwater management plans to new land use projects. We're willing to do that with the understanding that that 500 unit threshold remains the same. The reason for that is that that was chosen to be a part of the CEQA process. The sections that we're mentioning or that we're amending here are in CEQA. And I wanted to give you an idea. I brought with me a copy of an average, a typical water supply assessment. Here it is. This was done in 2015. It's for a project at the village at Squaw Valley, and it's over 220 pages. And this is an appendix to the CEQA document. And what lawyers do, I'm a lawyer, I know some of you are lawyers, and I actually practiced CEQA law, is that they go through this before it's released to the public, and then the other side, the opponents, go through it and make comments, and then the lead agency and their lawyers create a response to that, and then we have litigation over it. And we have litigation over every word, the backup of every number. And at the end of the day, if I were to ask the average person, after doing all this and paying the costs of those attorney's fees and the 8 years of litigation that go with it, do I get a right to the water? Is that water reserved for me by the water provider? The answer to that is no. I don't get anything for that process except 8 years of delay, the payment of 2 lawyers, because as the developer, I'm also paying for the public agency's lawyer, usually about $600 an hour, and I don't get a right to the water. So for us, while this bill in 2001 was put forward as a response to a court decision that deals with what the court characterized as paper water, This now has become paper without water. The water is there, but there's no ability to use it. And so we don't want to do anything that would increase the possibility of people having arguments without the practical effect of actually getting the water. So that's part of it. The other thing to keep in mind is that in 2001, we set the 500-unit threshold because that was what was a regionally significant project under CEQA, but realized that since that time, based on advances to the building code and the water efficiency landscape ordinance, the use of water in homes have become 50% more water efficient. That means without making any changes to the law, the amount of water that was used in 2001 for 500 units would now be 250 units. And that becomes the benchmark, by the way, for industrial uses, office uses, hotel uses. So you've had a decline over those 15 years as well. Suffice it to say that there are other reasons why we don't think it's appropriate to do that in CEQA, but there are 11 other points in the process of land use where we're also tying the project to the availability of water, which is why even today, we don't have any homes built in California that have no water for them. It is absolutely paramount that we don't begin construction on something that isn't going to have water for the buyer of that home. So it's provided from annexation. The demonstration is provided from annexation all the way down to the public report that the Bureau of Real Estate approves for us of who the water provider is. And of course, even after that point, a water agency can deny a connection even through the use of a declaration of an emergency. Let me just stop there and say I'd be happy to entertain any questions.
Oh, wait, take opposition. Please come forward, opposition.
Good morning, Yeli Govrich with the California Association of Realtors, here oppose unless amended, also echoing the comments from the California Building Industry Association. Thank you.
Thank you for your testimony. Any others in opposition would like to come forward at this time? And then we'll open it back up for questions. Senator Allen.
I heard some very interesting things out of the last presenter, and I'd love the supporters to respond to several of the concerns that were raised.
Yes, absolutely. Thank you. Thank you very much. Start with Mr. Cruz's comments relating to programmatic. I mean, we're open to some discussion on that rather than project by project, especially if we get down to under 500 homes, which isn't part of this bill, but who knows where it'll end up. But not everyone's in an urban water management plan area, which is revitalized. A lot of areas are, but mostly in, urban settings. A lot of these challenges where you have the most severely and critically overdrafted groundwater basins, 125 of them out of our 500 and something basins are those. They are not in urban areas. So that is one of the challenges that we'll have to work on. I get the concept instead of, if you can prove that there's adequate not only surface water supply, but groundwater supply, if that's what they indeed rely on for their water supply, if there's a way to programmatically look at something, but just using the urban water management plans doesn't cover everyone, so we have to figure that out, and I think we can. Relating to the other person's representative, it's sort of an interesting thing. I'd love to have the BIA be as concerned about the no one's responsible for the drought here, right? But we are responsible for managing our groundwater basins. And so how can we make sure we can not only grow crops on one hand, but grow homes on the other hand? There's going to be competing uses, unlimited resources, especially with the severely overdrafted basins. It's going to take years to replenish that water supply. the goal of this is, back to the show me the water things, if you're in an area that relies perhaps disproportionately on groundwater basins, and they're severely overdrafted, there's a management issue going on. There's going to be some competition going on who has access to that water. So this is the time to have that discussion. And we had recognized that we'll be needing to work with the BIA and others, but the realtors and the agricultural community all have interest in a growing limited supply of water. And we don't want to put new homeowners in a position of not having access to safe drinking water. I think that's why you're having the discussion of the 500 homes. Yes, I get the regional thing, but how does that overlap over the severely overdrafted groundwater basins? I think we have to be more thoughtful because, frankly, the public doesn't understand how we can have thousands of Californians who don't any longer have access to safe drinking water because a few people decided to drill to the bottom of the groundwater basins and it's lowered, and it's going to take potentially decades. Moving in the wrong direction, you're going to see more seawater intrusion, especially along the Central Coast and things. And so, Senator Monning, your district, Santa Beth, Jackson's, just, they have a lot potentially to lose. So what is that balance? No one's saying don't build homes. We're not saying don't grow crops, but we've got to recognize that just looking at surface water to make these land use decisions isn't good enough. So we're focusing on the Sigma half. The administration has gotten into the room because they're very interested in the Affordable Safe Drinking Water Initiative and providing access to particularly rural areas and smaller communities. So that number doesn't really fit. So we'll see what we can accomplish in this bill this year. I look forward to working with the opposition, but you can't just ignore the problem. The other bills are in effect. It only relates to surface water. That's not the real world anymore, especially in drought-like conditions when in some areas 60% of all of our water supply comes from groundwater basins, and too many of them are severely overdrafted. Working along with definitions on probationary and everything, we can work through those. That's not a problem, and I agree coming out after a project is denied and go back and redoing it, that the time doesn't work on it. So we'll be consulting some experts on CEQA and making sure that we can work through this, but the problem doesn't go away, and I need the BIA and the realtors in the room to make this right, but not ignore the problem. Yes, you can kill the bill, but what does that solve? It solves nothing.
Senator Hueso.
Yes, thank you. Senator Pavley, under this legislation, who would bear the burden of proving that water is available within the area that they're building housing?
I think that's already, when it relates to show me the water bills, it would be the agency that goes through the approval process when they're doing their checkoff list that there's adequate access to water for those people.
So normally it would be the regulatory body that's approving the permit.
Yes.
So the builder isn't necessarily held responsible for producing that data?
Well, I assume when you go through the CEQA process and they're going through the checklist on adequate supply of water, what's wrong is too much of this has been focused on just surface water, and it's different, as we know, in municipal areas where you have water agencies that have access to all the information. We've also taken an amendment, because it was brought up by some of the opposition, that the State Water Board that has access to information should be sending it down to the LAFCOs or the permitting agency. But we haven't done a job in relating to groundwater supplies and how that translates into assuring that there will be adequate supply to that water for development.
So you're making an additional requirement that groundwater be added to the mix?
Yes.
So currently, that can't be done in and of itself?
Okay.
without the
So
legislation?
groundwater and surface water is all in there, but how does it relate to the Sustainable Groundwater Management Act is the point of this legislation? When we're looking at the severely and overdrafted basins and bringing them up to speed, do you keep, you know the old adage when there's a hole, stop digging or something like that? We need to really be more thoughtful in how we identify adequate water supply and make sure our agricultural communities and our housing communities have access to water in the future and make some determinations.
So, I mean, we've had considerable legislation here on, from different legislators trying to hold the local agencies accountable for not keeping up with their responsibility of creating the right amount of affordable housing. And we know there's a backlog of affordable housing in the state. We have huge waiting lists that are people that are living in the state, consuming water while they live somewhere else, probably with a family, probably in inadequate housing, probably living in the streets. We have a bill talking about creating homeless housing. So, and coupled with the fact that our affordable housing fund is coming to an end, redevelopment set aside has come to an end, we're trying to identify ways to create affordable housing in the state. I mean, how does this bill help with that endeavor? I mean, does this give an out to the local governments by saying, you know, by us identifying that we don't have enough water, we don't have to comply with our affordable housing mix? I mean, are we giving them an out to produce affordable housing?
No, it's just whoever is going to be the user of the water that we want to make sure they have access to safe drinking water. And it is nothing to do with limitations on your requirements